welcome back to Between Parks Place and Capitol Hill, a Six News program all about law and government in Australia. I'm your host and GovCheck editor, Stuart Jeffrey, and joining me, as usual, is Aidan Edgecombe, our parliamentary reporter. We said we were having Dr. Christopher Rudge on again. He was on for our first show as well as GovCheck, so it's great to have you back on as well.
Thanks for having me, Stuart and Aidan.
So last time we did the intersex bill in the ACT. Would it be fair to say, at least among the public, that this is going to be more controversial? This new ruling, Cara and Attorney General from the federal court on the voluntary assisted dying.
Well, it's an interesting comparison. Very different things, although they're both broadly in health law and medical law, I suppose. One's a bill, whereas this is actually a decision on existing legislation. So hard to compare in a way, but I think ultimately this is perhaps a technical decision in the sense that you have harmonised or consistent legislation around the country permitting voluntary assisted dying, previously commonly known as euthanasia. And yet then you have a Commonwealth criminal law prohibiting suicide. Now, whether the Commonwealth government foresaw, the kinds of problems that arose here or not, these problems have arisen of inconsistency, essentially. Inconsistency between, in this case, the Victorian law and the Commonwealth criminal law. And so the application to the federal court was brought on the basis of a declaration. It wasn't an actual adversarial challenge, as it were. And Her Honour Justice Abraham has, in response to that, application for a declaration, made a declaration now that there is inconsistency between the Commonwealth law and the Victorian law, which means that the Commonwealth law prevails. So when I say technical decision, I mean we have a problem of inconsistent laws here, and whether that was really intended by anyone to be the case or not is kind of, I think we can put that to one side. And now the decision is whether that consistency is to be overcome or somehow becomes something debated.
So I know you say this is technical, but is it still also political in a sense as well, the judgment? Of course, not by Justice Abraham herself, but in broader context, would this also be a very politically active topic?
Certainly. I think, everything's political in my view, being a trained Foucauldian. But I think you cannot deny that the topic of euthanasia or voluntary assisted dying is highly political. And, over in Canada, the political debate is particularly pronounced now and has been for the last few years because the legislative arrangement to permit VAD, voluntary assisted dying in Canada, has been said to be broader than it has been legislated on here, insofar as people who are diagnosed with psychosocial disabilities or illnesses might also have access to voluntary assisted dying. That's not something that has been legislated in the States in Australia. But so definitely in the broader scheme of the decriminalisation, because we've just seen that it might be criminal if it happens in Victoria, for example, or in another sense, the legalisation of euthanasia or voluntary assisted dying. That is always a political topic, and it probably will be so until things are resolved one way or the other. And will continue to be so, but at least having legislative certainty will probably, over time, depoliticise it.
I'm glad that you mentioned the political tension of the issue, and you talked earlier about the disparity between the different state laws and the federal laws on this. Now, independent MP Kate Chaney has proposed and said she will introduce a bill which will exempt using the carriage service to discuss voluntary assisted dying, and then presumably make appointments, particularly for those in regional and rural communities who don't have the same in-person access to medical facilities as some people do. So that's obviously something on her agenda, and like you say, that's a political area. But how do you think, in terms of the small debate between whether we essentially, what she wants to do, decriminalize it, make it not a criminal offence to use the carriage services to discuss this, compared to the idea of legalization, which would have to happen on a federal level, then a complete federal legalization?
Well, I mean, I haven't seen any proposed members' bill. I'm assuming it hasn't been drafted quite yet. I'm not sure, but it's interesting to consider what it would take to overcome this decision of the federal court. In theory, I would think that a bill which says that a carriage service, i.e. telephone or internet advice or counselling, etc., in relation to voluntary assisted dying, etc., being carved out, as it were, or being kind of, words being given to that topic or that subject matter, so that it no longer offends the Commonwealth criminal law. In theory, I think that could work, but we just don't know that, because I don't think the decision goes that far. I think the real problem here, as I understand the decision, is that the word suicide, which and of course this is a topic that may give rise to kind of anxiety and issues among listeners. So I just want to put the warning out before we start talking squarely about this topic. But the issue here was whether the word suicide, as it is used in the Commonwealth criminal law, captured the wording and the meaning of the Voluntary Assisted Dying Act in Victoria, as you say, specifically in relation to the use of a carriage service. And the reasons and the decision found that it did. In other words, that the Commonwealth Criminal Code could be applied to instances in which a carriage service was used to share information about voluntary assisted dying in Victoria, such that it would be a criminal offence under the Commonwealth Code, prospectively, for a doctor to use a carriage service to deliver information about voluntary assisted dying to a patient in Victoria. So when we talk about decriminalisation, yes, that has to happen at the federal level. But the question I think that was posed earlier in relation to the bill is, well, does that have to happen? Maybe you can just amend the state legislation to not offend the criminal code anymore. And that's what I imagine the bill, the kind of, the prospective bill is trying to do. And the interesting question for me is that it seems, on my research, that the Western Australian law at the moment does precisely that. It actually has a provision that says, to be clear, the word suicide or the wording in this Western Australian law does not mean suicide. And so, but that wasn't the question put before Her Honour Justice Abram in the federal court. The question was in relation to the Victorian law, which, as I understand it, doesn't have that clarifying provision. So this is a bit technical, but effectively there's an inconsistency between the Commonwealth criminal law and the putting it, squarely or clearly, the state legalisation law in terms of euthanasia. And so how that's resolved is a matter of legislative tinkering. I think that at this point in time, it would be helpful for there to be some collaboration between the federal and state governments whether it occurs at a kind of health ministers meeting at national cabinet or some other relevant meeting, like involving the Attorney General and of the states and Commonwealth, to work out exactly what's supposed to happen here. But that's a political question. The legal question is how you deal with it as a matter of legislating. And we wait.
I see you snuck in a reference to cooperation versus referral power, which we were going to do, but then I had laryngitis. So unfortunately, we couldn't do that one. But I love that you now mentioned it here. We've got it out in the air, referral power versus cooperation. And I think in this case, it definitely is cooperation, kind of like universal
it's an
declaration laws
with
as well.
Cooperative stuff, though, because this is not an inconsistency between state law and Commonwealth law in a shared area like health. Now, as we know, the Commonwealth has no health power expressly, but they've been referred health powers by the states. This is not an instance in which a legal instrument in the Commonwealth law pursuant to health is inconsistent with a legislative instrument at the state law pursuant to health. This is across two different areas, so to speak. The Victorian Voluntary Assisted Dying Act isn't a criminal law as such. It's made pursuant to, I suppose, the health powers or other such powers. Whereas the Commonwealth law is squarely a criminal law. And so how that cooperation takes place is not in one area, which is what usually happens at the National Cabinet when these cooperative schemes are dealt with, etc. So it's actually a bit of a more, it's not a classic cooperative matter or even a classic referral matter. I think the Commonwealth is squarely permitted to make laws about criminal wrongs at the Commonwealth level, and the states are constitutionally permitted to make laws about health, and I assume that's the basis of this Voluntary Assisted Dying Act. The problem is that you've got this unforeseen, I think, clash of Commonwealth criminal law and state, put it one way, health law. And I don't think cooperative or referral powers are the answer. I think they just need to recraft the legislation so they don't bump into each other anymore, pursuant to some shared policy-making idea about what's really the priority here. Do they really want to, which will win at a political level across the Commonwealth? Does the Commonwealth really want to criminally prohibit voluntary assisted dying? I'm not sure that it does. I'm not sure there's evidence that there is. The problem really is that historically it did. And that's really where it comes down to. And that's where the politics kicks in, right? Because in 2005, the Howard government, I think as is very well known, did amend the criminal code to effectively create the same problem that we're dealing with now by design, which is part of the reasoning of Her Honour Justice Abraham. In other words, the Howard government meant, and I think that's implicit in the ruling of Justice Abraham, meant for the Commonwealth criminal law to own the space of euthanasia and voluntary assisted dying. And a bit like what happened with same-sex marriage, do you remember that? When the ACT attempted to kind of test whether it could legislate contrary to the Marriage Act at the Commonwealth level, and it was found that it couldn't. I think the same thing has happened here. And we've effectively had the test case now. And, it's a bit different because the Commonwealth doesn't have a Voluntary Assisted Dying Act. You know what I mean? So the Commonwealth has to decide whether it really wants to own the space anymore. And if it doesn't, then the states could possibly recraft the law to escape the application of the Commonwealth Criminal Code, or the Commonwealth could itself make an exception for voluntary assisted dying so that the suicide language doesn't capture the state law.
Well, thanks for mentioning the ACT situation. I know this is a plug here. If you want to find out more about that, I think it was an early Commonwealth Knowledge article, I think number 3, where I actually went over that topic. So if you want to go reread that after this, feel free to. I might try and get Leo to put a link in this one. But just to backtrack very slightly, what's a carriage service? I presume it doesn't involve carts and horses. I presume it's something more than that.
Yeah. Telehealth, telephone, email, Zoom conversations, anything that is effectively, I mean, of course, it comes from pigeon carriers and telegrams where things were, in the physical and old literal sense, carried from one location to another. Post telephony and post digital communications, messages can be carried from one place to another by way of digital data, transmission. So it would include, it is quite broad as I understand it, and there's different definitions in different acts, but it effectively applies to anything in which where data or messages, audio or visual, are carried from one place to another. So I think it's important, if, as we alluded to, I think before we started recording, in rural or regional settings where medical services are difficult to access, especially specialized medical services, it seems inevitable that telehealth, is the best option for people living in those regional areas. And so, if it were the case that someone in a regional area were seeking information about their options in circumstances where such was their health that they were interested in, ending their life in a controlled and lawful way, according at least to the legislation we've been discussing. If they were to begin those conversations and a medical practitioner authorised to do so were to share information about their options, the Commonwealth criminal law would currently kick in and make those transmissions contrary to the criminal law, effectively making the medical practitioner's counselling and advice about those options a crime because it is aiding and abetting suicide under the Commonwealth criminal law. And so it would potentially cover text messages. It would potentially, although I don't expect any medical practitioner would be giving such information via text message, but technically the breadth of the word carriage service could be quite expansive.
Thanks for clearing that up, of course, just because, like you say, it comes from the days of pigeon carriers, so it's rather old terminology. You mentioned the whole remote areas thing and also briefly ACT with the same-sex marriage, and I think this is a good time to mention the Territory Rights Act, which was passed last year, because as far as I'm aware, Northern Territory in 1995 was the first jurisdiction in the world to legalize voluntary assisted dying, and of course that ended up being overridden by federal legislation. But now the two territories are in the process of crafting their laws. I've seen something about Northern Territory and considering about whether dementia will be included in it, and of course ACT, there was a bit of a drama about children who also have terminal medical conditions, and you talked about the sort of need to cooperate on a state, federal, and then now I guess territory level, because if the Victorian case has exposed this problem, and you said it was a deliberate problem with the Howard government's wording of the law, but it is still a sort of an inconsistency, and in order to address it, it would help to have this cooperation on a state, federal, and territory level. So what do you think this decision means for the two territories? They may have an advantage in this space given they haven't legislated their laws yet. So it would be more than a minor altercation. It would be they're in the process of writing them up. So I suppose they can use this to definitely make sure in crystal clear that, there's not going to be any further issues.
Yes, and thanks for that potted history of the Territorian kind of early approach, and as you say, global first approach. So yes, I think it was the Rights of the Terminally Ill Act 1995 in the Northern Territory, which permitted voluntary assisted dying at that time in the mid-90s. But that was overturned by the Euthanasia Laws Act 1997 at the Commonwealth level. So this is not a new story, is it? You've had a kind of tete-a-tete, a back and forth between territory and state lawmakers and the Commonwealth responding in kind to prevail over the laws made by the Territorians in this case, and states perhaps now, since the 90s. And interestingly, in this case, however, it's not as though the Victorian Act was, legislated or enacted, and then the Commonwealth responded, actively post enactment of the Victorian Act. Rather, it's the ghost of the Commonwealth that returns from 2005 to pull away parts of the Victorian Act. In other words, because Parliament in 2005 wrote laws that, according to the ruling of Justice Abram, intended to capture euthanasia and voluntary assisted dying into the criminal code of the Commonwealth, that definition, or that expansion, or that rather broad definition, still continues today. And obviously the Victorians didn't foresee that. But I think your point, Aidan, is right, that now the territories are at an advantage having Justice Abrams' ruling in hand, because they can use that to design and craft laws that seek to evade or elude the kind of prohibition that the criminal code imposes. Now, that's for the drafters and the policymakers to kind of organise in terms of how they do that. But I think, expressly saying that voluntary assisted dying does not mean suicide, and, adding a bit more around that, would be, prospectively one way of approaching that problem. Not necessarily a way that will work, but they could do things of that nature, I think, now that they have the reasons of the federal court.
Now, you mentioned advantages there, and of course, we did have New South Wales bring their legislation into force just before the federal court ruling, and again, they had the advantage of looking at every other state's laws, and they actually borrowed from Queensland because they mentioned protecting vulnerable persons in legislation. That's taken from Queensland, where, of course, there's more protection for them there. It's explicitly mentioned it was the purposes of that act to ensure that there's no exploitation of vulnerable persons. And that was something that was raised quite a lot in this judgment, is the need to protect vulnerable persons. Now, of course, that isn't defined in the Victorian legislation or Western Australian, Tasmanian, or South Australian, but it is mentioned in both Queensland and New South Wales. So could we see any chance that those laws potentially surviving this ruling that could lead to the Victorian laws and other laws being struck down completely?
It's a good question. I'm not sure I can answer with respect to sections, chapter and verse of the New South Wales or Queensland law in respect of vulnerable persons. But I can speak briefly to the federal court's decision, because when the federal court looked at the purpose of the Commonwealth criminal provisions that criminalised aiding and abetting suicide, and it was asked by the applicants and respondents in this matter to determine the purpose of those laws, the 2005 amendments that were created to stop vulnerable people from being subjected to pressure or coercion to take their own life. Her Honour, Justice Abrams, said, yes, that was a purpose of the Criminal Code amendments in 2005. In other words, the federal court said, well, in 2005, the Commonwealth expressed its concern that vulnerable people could be subject to pressure or coercion to take their own life. This is the words of the federal court, in making its criminal laws. And that was part of the reason that it criminalised using a carriage service to aid and abet or discuss suicide. Now, since you say the Victorian Act didn't address, and I take your word for that, I haven't confirmed that, but if the Victorian Act didn't address vulnerable people, then there was nothing for the federal court to deal with, as to whether the Victorian Act made some, allowance or did something at the legislative level to deal with that problem that vulnerable people might be coerced or pressured. And that's a very serious problem. I know we're talking quite technically about the law, but I don't think any person, no ethicist or lawmaker or politician, is writing off the problem of coercion and of pressure, in terms of vulnerable people who might be, considering their options in circumstances where they have a serious illness. That is a serious consideration for all people on all sides of this discussion, I think. But the question is, how is that dealt with in the Voluntary Assisted Dying Act? What guardrails, what strong, kind of principles of decision-making are provided in those legislative acts to protect vulnerable people from being subject to pressure or coercion? If the Victorian Act was not speaking to that directly, then obviously the purpose of the criminal code to protect those people kind of spoke over it. And that was one of the reasons that the criminal code effectively prevailed over the Victorian law here.
Questions of legal ethics are always going to be complex, and they're going to be controversial. So it's probably, given the subject, I reckon it's probably best to stay away from those for the most part, especially given that we have at the end of the time we have allotted for this discussion. But thank you once again for joining us for this show. I know it's not entirely in your area of expertise, but I was like, do I know any lawyers or any professors that deal with medical issues? Oh, yeah, you do. So thank you for giving
I totally accept that. I mean, I have not published writing on this topic, although my very esteemed colleagues at Queensland University of Technology and UTS are experts in the area, notably Professor Ben White and Wendy Limit. I do teach consent, so I'm happy to offer my insights. And I think the interesting part of the federal court decision is that it is quite technical. It's not necessarily about the deeper ethical issues. It's more about the meaning of two seemingly, and now it has been confirmed, definitively contrary pieces of legislation.
For the audience, at least, we don't have any topics picked for next time. It is the holidays for school. It's school holidays for Aiden, and I'm wrapping up my uni trimester for the year. Over the summer, of course, we don't have Parliament sitting, not many court cases, so we get a chance to do a bit more theoretical look. I know we're currently looking at considering a bit of comparative law. Why should we consider other countries and what their laws mean and how they could influence our own laws in Australia and some of those sorts of topics. And also, I've got a few case universities coming up as well. So definitely stay tuned for those ones. But once again, thank you, Aiden and Chris, for joining me for this.
Thanks, Stuart. Thanks, Aiden.